I've always done it this way, so why do I need to change? That attitude from a gym owner is very scary. Because you've never gotten in trouble does not mean you never will get in trouble. And as you've said now a couple of times, you can't wait until you get in trouble to then worry about whether or not you've done everything you need to do in order to either avoid the lawsuit or survive the lawsuit. So that mentality, it is unfortunately one we see in child activity centers a lot. You can't protect yourself against absolutely everything. If you don't want to put yourself at risk, don't open a gym.
I'm certain, 100% certain that these insurance companies are looking for a way to not pay.
Oh, of course. And that's why your insurance is your second line of defense behind your initial line of defense, which is that liability waiver. One of the worst things you can do is either one, not have a liability waiver that applies to the services that you're offering, or two.
Hi, my name's Andy Seeley, and this is another episode of A Family Business. And we're lucky enough to be chatting with Matt Becker, who is a high-flying attorney in the family business world. And we're very lucky to talk to him about, risks and management of risks and so forth. I'm really glad that you're here with us today, Matt. Good to see you.
Thanks, Andy. Real pleasure being on the show. In gymnastics, isn't it a giant when you go like all the way around the bar?
Yes. Yeah.
Okay. There you go. That's my high flying moon. I've never done one. I think I got parallel once to the ground on a pull up bar doing like some hollow arches, and that was like as far as I think I freaked out.
Right, the best I think I've ever done is like flying off the side of it, like trying to hold on. I've never done a giant either. So, but good to meet you. Good to have you on. We're going to talk a little bit about legal stuff and things to be thinking about. We're not going to get too deep into the weeds of it. If anybody does want to get into the weeds with anything with Matt, please feel free to reach out to him. We'll put all of his information in the information below if you want to have a little look and reach out to Matt and you like what he's saying. So first off, let's just get straight into some of these questions that I have. So
sure.
I want to talk a little bit about the biggest legal risks that gym owners don't even know they have. People are constantly being surprised by stuff. So what do you think is some common legal blind spots that gyms don't really think about?
Yeah, before I get in, since I'm an attorney, I got to have a disclaimer that nothing you hear on this podcast will be taken as legal advice. It's all meant for educational purposes, unless you've reached out to us and we represent you directly, and then you can. Otherwise, if you want the actual legal advice, yes, as Andy said, you got to reach out to us because I don't know your specific situation. Now, with that disclaimer, Andy, I'm going to say there's sort of three levels of common legal exposure that we see in gym owners that they don't know about. And that really comes along with what we refer to as sort of like your three levels of protection. Okay. And I'll go in reverse order. So the first is your legal entity, your LLC or your corporation. And most gym owners do this on their own. It's not a terribly difficult process to go on your Secretary of State or Department of State's website and go through the process of just filing the LLC and then go out to the IRS website and get your federal employee identification number. The problem is the actual LLC setup does not stop there, or the legal entity setup. The most common thing that we miss is what is known as the corporate documentation. So in corporations, we have shareholder agreements and bylaws and officers, and then in LLCs, we have operating agreements. And even if you're a sole owner of your legal entity, you still have to have this corporate documentation. And without it, you leave yourself open to an argument that the LLC or the corporation was never actually completed in its setup, therefore isn't providing you that level of protection or even that shield of protection that it's designed to do. The second area we see where there's a lot of common legal exposure that gym owners don't know about is in their insurance policy. Whether the insurance policy doesn't actually cover what they do, as opposed, in comparison to general liability versus professional liability, or sometimes getting into the weeds of that insurance policy to realize what exclusions are there. And so the gym owner might be doing something at their gym thinking they're completely covered when really there's an exclusion deep down on page 75 of that policy that says the gym owner isn't covered for this. And then the third area is literally in the liability waiver. And this is like your first line of defense against the personal injury lawsuit. Whether or not your liability waiver is compliant with your state's legal nuances around that liability waiver, whether the liability waiver is actually applying to the services that you're offering, or in the instance with, child activity centers, whether or not your state even says that your liability waiver as it applies to minors is even legally enforceable.
Right. So grabbing a liability waiver from iClass Pro or Jackrabbit, or using a liability waiver for a friend who owns a gym once is probably not necessarily the best sound legal advice or legal move that a gym could do.
That's correct. Yeah. Because even if your gym owner friend is in the same state as you, you're making a big leap that theirs is actually done correctly. And then you're just taking that and assuming yours is now done
Right.
correctly. And I got to say, in about 5 years of doing this, I've maybe seen like 4, maybe 5 liability waivers that I've reviewed that I actually had to go back or went back to the gym owner and said, this is great. There's actually nothing of value I can add on this. And that's probably, reviewing 4 to 5 liability waivers a week.
Right. Okay. Well, so basically with that, there's probably an element of false sense of security that a lot of people have, and they just are running around. I mean, I don't want to fill people with fear, but it's just about getting
No.
ducks in a row, right? It's like,
Right.
it's just about having your ducks in a row. And, I know a lot of people have attorneys, but they kind of wait until they need an attorney rather than thinking, maybe I need an attorney just to make sure I've got my ducks in a row. They think, okay, I need an attorney when a lawsuit happens.
Mm-hmm.
So why do lawsuits happen? Typically in your experience, why do they happen?
Yeah, so it's a common misconception that we have to wait till we have a problem in order to then reach out for legal help. As a business owner, you have to be proactive. The 3 most common lawsuits that gym owners are going to face are going to be the personal injury lawsuit. That's the one that, child gets injured, dog gets injured, whatever in your gym. Membership issues, consumer protection issues, where your state says you have to handle your automatic recurring payments in a certain way under a contract that says certain things, and you don't have that in place. Well, you've just given a disgruntled parent a reason to go make a consumer protection claim on the Attorney General's website for your state, and then they come knocking on your door. And the third is staff classification issues. So employees versus contractors versus bartering, and what sort of legal issues we have around all of that. And then your state Department of Labor or your California EDD comes knocking on your door, and turns out you've got your staff classified wrong, and now you face a bunch of fines and penalties.
Okay. So, yeah, I mean, it's a little bit like, I think I even mentioned this to you once before, is like, you don't borrow money when you need money. Like, you should set up your lines of credit and everything when you don't need it, because when you need
Right.
it, it's maybe a bit too late. It's
Right.
maybe you're not quite on it. So what's the legal mistake that scares you the most? Like, if you just choose one as an attorney, let's say you were my attorney, what would be the biggest mistake that I possibly could make that scares you the most if you just chose one of them?
I've always done it this way, so why do I need to change? That attitude from a gym owner is very scary because everything changes. The law changes. What a liability waiver looks like today is not what it looked like 5 years ago. Consumer protection laws that are out there today were not out there 3 years ago. And because you've never gotten in trouble does not mean you never will get in trouble. And as you've said now a couple of times, you can't wait until you get in trouble to then worry about whether or not you've done everything you need to do in order to either avoid the lawsuit or survive the lawsuit. So that mentality, and it is unfortunately one we see in child activity centers a lot. Because like in the adult fitness boutique or boutique fitness area, they buy the gym, they own the gym for 5, maybe 10 years if they're lucky, and then they sell it on to usually one of their coaches or somebody else. People in like cheerleading, gymnastics, dance, swim, they own these things for 15, 20 years. And so we do kind of fall within that old school mentality of like, well, I've never had a problem, so I don't need to make a big deal out of this. And that scares me the most because then there's now an uphill battle of trying to explain to that gym owner why they need it, let alone what it is that they need.
Right. And that is something that you hear, right? Or we hear is, well, I've always done it this way, or we've always, everything is changing. Technology is changing. Law changes all the time. I mean, law is constantly changing. Politicians are always trying to figure out why, show that they're worth something. They're going to constantly be passing laws. And sometimes it's like, why did we pass that law? Unless you're like watching everything that they're doing, which none of us are doing. I've know of multiple laws that I found out about years later, realizing, oh, geez, I had no idea that they made that change. And it didn't even make sense that they made that change, but they did make that change, and they need to have somebody who's on top of it. You probably need to review all your stuff probably once every couple of years. Would you agree?
We recommend once a year, just to reach out to us, especially if you're in some of the more litigious states, New York, California, New Jersey, Washington, Massachusetts, because they do tend to change, especially California, quite often. And even we try to stay up on it. And every so often, we'll even get a client that reaches out that says, "Did you hear about this?" And it was like, that was passed 2 months ago. We haven't had time yet, but now that we're looking into it, yeah, I mean, because they change, you're keeping track of 50 different states plus the federal government and what they're all doing. Yeah, that alone can be a full-time job.
I guess when we're talking about reviewing, it could be reviewing, are you doing your LLC or your corporate meeting notes correctly? Is your waiver or your contracts up to snuff? Is your processes and systems correct for if something does go wrong? There's a lot of things, right? Because a good attorney, when someone breaks their back in your location, is going to do everything it can to find that one little thing that opens the crack that allows them to come through and try to get the largest settlement. Because their goal is not to be nice to you, but to make sure the person that broke their neck or whatever it is has lifelong funds to get along. And unfortunately, sometimes, and this is a question that I wanted to ask you, thinking about insurance solves everything. I'm certain, 100% certain that these insurance companies are looking for a way to not pay.
Oh, of course. Of course.
So what's your thoughts on insurance solving all the problems?
First, insurance is a necessity. Like, don't try to run your business without insurance. But you're right. The insurance is going to look for any and all reasons to deny you coverage. And that's why your insurance is your second line of defense behind your initial line of defense, which is that liability waiver. And one of the worst things you can do is either one, not have a liability waiver that applies to the services that you're offering, or two, just sometimes it baffles my mind. They didn't even get a liability waiver signed. And, in those instances, you just gave your insurance a prime reason to deny you coverage. It's very important to not only make sure that your operating procedures guarantee that a waiver gets signed, but, we'll see things like you've got open gym or Friday open play, whatever, and your waiver doesn't even address what's known as premises liability. Or you've got kids under the age of 18 as employees operating classes, yet your waiver says you provide qualified supervision in everything you do, and your state law says a 16-year-old can't provide qualified supervision. And so you therefore said something in your liability waiver that's basically a lie and doesn't apply. There you go. You just gave your insurance a reason to deny coverage.
That's scary. I bet you there's a lot of gyms out there that might have 16-year-old or 15-year-olds doing some coaching, and they might be doing a good job, but state law says that they're not supervisors. They're not necessarily highly qualified staff members or whatever it is. And that's enough to pierce the waiver, I guess. So I'm hearing that waivers aren't worthless.
Correct.
Depends on the waiver though, right? Some waivers are. Some waivers are. So waivers like parent signatures opposed to other people's signatures, digital versus paper. What are the limitations of waivers?
Digital versus paper is no longer a big deal. There are 3 levels of acceptable e-signatures: the click button acknowledgement, the typing of your name, and like the e-wet signature. All 3 are recognized across states, across federal law as acceptable. Now, the click button is easier to attack than the typing of the name, which is easier to attack than the writing of the actual wet signature. So that's okay. Beyond that, the liability waiver, as long as it is applying to what you are trying to do and it fits with your state's laws, the question then kind of becomes, is this ordinary negligence or is this gross negligence? Gross negligence is, I knew or should have known that there was a problem. I did nothing to avoid it, and now you ended up injured, okay? Ordinary negligence is what every gymnastics gym in the world probably has some kind of raised surface. I tripped over to the raised surface. It's ordinary course of business that every gymnastics gym is going to have this raised surface. That's probably ordinary negligence, unless it was pretty blatantly obvious. And that's why you see like yellow tape and pink tape and crosses and everything on like stairs to try to make it more obvious. In the event of gross negligence, your waiver will never cover you. There's not one state that says you're allowed to waive gross negligence. And that's where we get people say, well, waivers don't work. No, they don't against gross negligence. Ordinary negligence is what the waiver is there to protect you against.
So like gross negligence might be somebody's throwing a mat at kids because it's fun, because the kids are laughing and bouncing around, and some kid gets thrown into a concrete wall or something and smacks their head open, and that would be gross negligence because, hey, you're doing something stupid that shouldn't be done, and somebody gets injured and blah, 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 right? And,
or the student comes in and says, my ankle hurts today. I think I might have a stress fracture. And the coach says, it doesn't matter. We have a competition on Saturday. Get on the floor and start doing your routine. Does a bunch of back handsprings. boom, snaps the ankle.
Right. Okay, cool. So waivers can protect gyms
Yes.
to a degree. How do you protect yourself against gross negligence from a staff member? Like if you're a gym owner, some gym owners aren't even in the gym half the time. They've got staff, they've got managers, they've got employees that are running the location. How do you protect yourself against gross negligence? Like, obviously, let's say you've got really good management team. Let's say you got a 17-year-old coach who's just having fun with kids, doing something silly, like I said, someone gets injured. How do you protect yourself against that?
Well, that is where, I mean, you better just have a good insurance policy that's covering you for one. Okay. But
Because the insurance company will pay for the legal fees, right? I guess.
yes, the insurance company should be covering your legal fees. And hopefully your insurance coverage covers all of your employees and minors and everything else. So those are little nuances that we have to look into within the insurance policy. But you can't protect yourself against absolutely everything. If you don't want to put yourself at risk, don't open a gym. And that's why, there's
I
the
guess
strictly
training. I guess if you're showing that you're training, that you're telling people that you shouldn't throw, mats at people, that if it's shown and you've got training, you could probably argue in a court of law that we've done everything we can.
Yeah.
And maybe you don't avoid the insurance company having $1 million payout, but you at least don't lose your business and you don't lose everything that you have.
Right. But having good systems in place, having those reviews, maybe having cameras in your facilities that you can spy in every once in a while. There's a lot of attorneys out there that will put their strict legal hat on and say, like, never own a gym, it's too much liability. Well, okay. But that's where I come into play. And I'm like, well, I've got a legal hat and I have an ex-gym owner hat. So which hat do you want me to wear? Because I can tell you very strictly, like, yeah, if you're that scared of it, don't open a gym because you're never going to avoid absolutely everything. And
Right.
to your point earlier, even if we try to avoid absolutely everything and the child still gets injured, there's nothing necessarily stopping the parent from suing you. And that's why, you get that liability waiver so that they take the liability waiver to an attorney and the attorney looks at that and says, I ain't touching this with a 10-foot pole. But then maybe they do. And so then you fall back on your second line of defense, which is your insurance policy. And then if it exceeds your insurance policy, you fall back on your third line of defense, which is that LLC or corporation, which then is either going to absorb the lawsuit or the lawsuit's going to bounce off of it. And because you can't prevent somebody from suing. You can have a covenant not to sue within your liability waiver, but the only way to enforce that covenant not to sue is if somebody sues you and you file a response to their complaint saying,
You just
well,
make it as difficult as possible, basically. You make it as difficult as possible because you've covered as many bases as possible. And attorneys, especially if it's a contingency situation, which is, I guess, a lot of personal injury attorneys are, they're going to look at it and go, what's the easy money?
That's it, right. How easy can I get this money? Yep.
Right. Okay, let's have a look here. So staff, I've always subscribed to this. Your staff are your biggest asset and your biggest liability all at once, right? In fact, there's a lot of people out there that will say that you're most likely, if you're going to be sued by a staff member before you get sued by anybody. Is it your experience as a business owner?
Yeah, I would say there's probably more instances that you could be sued by a staff member than sued by a client. I can see that because really your client's going to sue you for a membership issue, which is unlikely. Again, it's going to be the consumer protection division or a personal injury. Whereas, staff member, you've got discrimination, you've got wrongful termination, you've got unemployment compensation, you've got workers' comp. Like there's just multiple different areas there, wage payment collection issues.
And again, depending on what state you're in, it could be a lot.
Some states are going to be a lot worse than others. Yep.
Yep.
And giving the staff members legal issues to go after the employer for sure.
What would you recommend when it comes to hiring staff? Like if you were recommended from a legal standpoint or an attorney standpoint, what would you say to your clients from a hiring and training standpoint for your clients to be thinking of?
So first, don't use your employee or staff handbook as your sort of like contract. There should be 3 levels of staff agreements or 3 levels of staff documents. The top level is your actual legal contract. It's either your employment agreement or your independent contractor agreement if you're going to have contractors. Your middle level is your staff handbook, which has your policies and terms. And then you have your standard operating procedures along the bottom. What we'll see is that they don't have the employment agreement or the independent contractor agreement, and they're either just having the staff member sign an offer letter or having the staff member sign to acknowledge the staff playbook or the staff handbook. And the problem there is if you don't enforce the staff handbook on one person, say you have like a no cell phones policy in class, I violate that, but I happen to be your best coach. So you're like, I'm going to overlook this today because Matt's my best coach and I can't afford to lose him. However, you've got another coach you don't really like. And the moment you see them using your cell phone, that's your reason to fire them. They're done. Well, you've now just addressed or applied your handbook differently to your different staff. And some states are going to say that just negated everything. So you have to have this employee handbook or the employment agreement or independent contractor agreement overhead that creates the legal relationship. And for employees, allows you to put contractually into this document what is going to be considered for cause termination. Because one way to avoid a lot of these common lawsuits that we just sort of rattled off, wrongful termination, unemployment compensation claims, workers' comp claims, maybe not so much workers' comp, but is whether or not you've terminated that employee for cause. Then from there, we have a solid handbook that tells the staff member exactly what they are and aren't to be doing, how they request time off, what rights do they have under, say, like the Family Medical Leave Act, those sorts of things, but also doing quarterly reviews with your staff. Those are huge when it comes to ending up terminating a staff is have you sat down on a quarterly basis? Do you have criteria that they should be marking off? Is that criteria in your playbook or handbook that they now know about? And are you keeping score? Because then you're creating a history that says repeatedly, we've sat down for the last 3 quarters and had a problem with the same issue. I'm now terminating you.
Right.
And then when they turn around and try to make a claim against you, you've got that history underneath an employment agreement that says, if you do X, Y, and Z, we're going to terminate you.
Would you have the same process in an at-will state compared to a state that isn't at-will?
Yes, because the at-will or the non-at-will states just tell you that you have to give them an opportunity to, you have to give them an opportunity to correct the problem. Doesn't mean you still can't terminate them for the problem. But in either instance, you're giving somebody the right to bring a legal claim under the state's employment laws.
Is it right to work or at will? What is it right to work? What is
it's at will versus right to work.
Okay. All right.
Yeah.
Those are the two different. Because a lot of people say, hey, if it's at will, I could fire you because I don't like your t-shirt.
That's technically true. But then they're going to go make an unemployment compensation claim.
Right.
And if you did fire them just because you didn't like their t-shirt, but you don't say in your handbook that they have to wear certain t-shirts as employees, well, then that's not for cause termination. But, the gym I owned an adult boutique gym. I said in my handbook that you had to wear a black shirt, gray shirt, blue shirt, white shirt. That was it. Could not be co-branded with something else. Like you can't come in here wearing another gym's t-shirts or anything like that. And ideally, it has our logo on it. But if you didn't have our shirt that day and you just wore a plain white shirt, fine. That was great. So if they come in and they're consistently wearing yellow shirts or they're wearing shirts from other gyms, and when I terminate them for that, I now have a defense that that's for cause termination because they violated my handbook.
Okay. What are common mistakes that employees make that cause the liability? That I know we spoke a little bit about it, but in your mind, what is a common error and not even like a gross mistake, right? But what are common employee mistakes that tend to lead to liability?
I'll tell you, I don't know if these are common mistakes. I guess. I mean, the two areas that we see this pop up most is unemployment compensation and workers' comp. So you terminate somebody, they go make an unemployment compensation claim, or they get injured and they go make a workers' compensation claim. If you have employees, I think the biggest mistake you could make is not knowing that you have to have unemployment compensation or workers' compensation. Different states are going to say different things, whether it's from one employee, you now have to have these policies, or if it's 10 employees, you now have to have these policies. So that would be probably, the biggest place where the gym owner is going to be caught without having the right things. Now, in the child activity centers, you guys usually just make everybody W-2s. So we don't worry too much about misclassification, but just as sort of the word of caution around contractors, certain states are going to allow you to have contractors within the fitness business, independent contractors. But again, that unemployment compensation and workers' compensation claims are the two biggest areas of exposure when the Department of Labor comes knocking on your door wondering why this contractor made an unemployment compensation claim and your response was they're not covered because they're an independent contractor. The state's going to go, oh, that's a red flag. Let's investigate whether or not that's true.
Right. All of a sudden, all of your employees are contractors. They're going to be like, well, this doesn't really fit, especially if you do it in a state like California where basically The
You
only
cannot.
contractors, I don't even know. I guess the only contractor that you could hire is a plumber to fix your plumbing when it leaks, right?
It is incredibly hard to have a contractor in Massachusetts, Washington, and California.
So when it comes to social media, this is kind of more my background. Although, let me just ask a quick question. Going back to the insurance, it's in my head before we go into social media and the digital stuff. When it comes to insurance, would it make sense for your attorney to review your insurance to just make sure, like, to have a
Sure.
look at it, make sure that it's kind of, I don't know what you could do with the insurance company though, because the insurance companies do whatever they want to do. But what can you add to a client's life, I guess,
Yeah.
by looking at their insurance agreement?
I'll give you a couple common examples. Gym owner reached out the other day, asked if we would review their insurance policy. We said, yeah, sure, send it over to us. What they sent was equipment coverage policy. And I said, is this the only policy that you have? And they said, yeah, this was all the broker said that we needed. So they have no general liability coverage. So if somebody comes in the gym and injures themselves, falls in the bathroom, trips over something, they have no coverage. If the client claims that they got injured because the coaches told them to do something and that was the reason they got injured, that's professional liability, no coverage. The only thing that this gym owner had coverage for is if a piece of equipment breaks or if there's a flood and everything is ruined. So they just didn't even have the coverage, even though their broker allegedly told them they had coverage. So that's sort of like one common area where I can look and be like, you don't even have coverage. Then we have this general versus professional liability distinction, in which a lot of run-of-the-mill commercial policies will provide general liability, but not professional liability coverage. And we see this as a problem because the broker doesn't understand the business. They just go, hey, I need a policy that is going to cover gymnastics. And they go, oh, okay. They sell you some policy that just has general liability coverage.
Right.
And then the third is having somebody who knows the industry looking at the common exclusions to determine whether or not there's going to be a lack of coverage. An easy place where this happens is, let's say you do everything primarily in the gym, but every Friday you go to your local rec center or something like that in order to hold like a community class. Your policy is going to have what is known as the designated premises, which is the gym where you're operating. It's your address. This is where the primary operations function. Once you leave those four walls, there's now a question of whether or not your insurance continues to cover you. And it's known as a designated premises exclusion. And if your policy has a designated premises exclusion, which a lot of policies do, the moment you go outside your four walls, you're no longer covered. So every Friday, when you go to the rec center to have your community class, if somebody gets injured and makes a claim off of that, your insurance will instantly deny coverage. So not only is it important to make sure that you actually are covered for what you're doing, but having somebody who knows what your industry does and how that impacts what kind of policy you need is also just as important.
Right. So, like, and there's a lot of gyms that will have mobile gymnastics that they offer. They do lots of different things. Just
Yep.
because you've got insurance for 600 kids or whatever doesn't mean 600 kids wherever, or it may not mean. It might mean maybe you do have coverage, but maybe to get it looked into to really understand what that is. And okay, that's good. Anyway,
Yep.
moving on
Okay.
to social media and digital world. I'm mainly going to talk about, like, for me, a lot of times our biggest thing what we want our clients to do is capture user content, right? So showing that kids are enjoying themselves, showing that parents, maybe even filming a parent talking about why they love their kids coming, all that kind of stuff is great for us to use.
Mm-hmm.
But there's some things to be thinking about when it comes to that stuff, right? So what legal kind of coverage should you be looking for? Can you even put it in the agreement? Like, can you just do a blanket that says by coming into this gym, you waive the right to us being able to use photos and videos of your children and everything? Is that even possible, or is that a reasonable expectation for you to ask your parents to do? What's your thoughts on all of that stuff?
So that belongs in your liability waiver, not in your tuition agreement, which is where we
Okay.
usually see it is, unless an attorney has written it, we see it buried in their payment policies or their tuition agreement. It needs to go in the liability waiver. At base, it needs to be what's known as a likeness waiver, which is just an acknowledgement that I may take a picture or video of you and your kid and that you're permitting me to use it. In our language, we usually go for like anything that the gym owner decides they want to use it for. And maybe about once a year, I get pushback on that. That's fine. Then we just modify the language to say like any marketing or media. The problem is that used to be okay 5 years ago when phones weren't as robust as they are now, or when everybody didn't think their image was worth $1 million. So it used to just be like one couple sentences or a paragraph is now basically like 3 to 4 paragraphs long, because first I have to acknowledge that I can take your picture and video. Next, we have to be able to acknowledge, is this audio or only video? If you have security cameras, you likely need to get two-party consent to put somebody on notice that you're using security cameras, especially if they're audio security cameras. And then finally, I need to waive my copyright to my likeness so that you don't use my image in your marketing, get a lot of benefit and return off of my image. And now I go, okay, hold on a second. You just got 5 new members because you posted me doing a giant on your social media. I should get some advantage, like financial advantage to that use of my image. That's not something we used to worry too much about, but now we do.
Because of the influences and you're right. So is there anything that you have to be thoughtful of? I'm not sure that there is, but like from a review standpoint, like reviews and what people say about you online and I got into a legal wrangle with a company like years ago that wrote a bad review, but out of spite. It wasn't based on anything. And we forced them to take that review down because it wasn't based on any reality. It was based on them being angry. Reviews to me are exceptionally hard to deal with. Usually Google and Facebook and all of them, they usually will do almost nothing. We usually teach people it's how you react to the reviews, which is more important than the review itself. And more importantly, to offset reviews, bad reviews, have lots of good reviews. Like if you've got 8 great reviews for every 1 bad review, probably most parents are going to look at it and go, that's a problem. But from a legal standpoint, is there anything to be thoughtful about?
In preventing the review, as you mentioned, it's very difficult to prevent the review. And then it's also going to be very hard to get that review taken down from this service like Google or Facebook or something like that. I would imagine what you did, you don't have to share too much, is you probably threatened some sort of libel defamation. And that's about the only way that you can do it. And we'll get gym owners that call up every once in a while about the disgruntled parent that's going on social media and blasting them or left a 1-star review and they want to sue them for defamation. Oh, there's a couple of different legal elements that you have to reach on defamation. One is it has to be a statement that's made to the public, which usually these are. Okay, it's on social media on a review. 2, it has to be true. So that was, probably a big basis for yours is like, this is just patently wrong. Okay, and then 3, usually you have to suffer some kind of damages as a result of it. And we usually have number 1, which is a statement was made. And they made it in writing. They put it on my Google, business page. 2, was it true? Maybe. Okay, that's usually like
you have
50.
to prove that like my experience was we proved that it wasn't true, but you have to prove it, right? You can't just say, well, it's not true when this person says it is true. And because then it's just hearsay. It's just, this is my opinion, your opinion. And it's tough. And we wouldn't have pursued it if we couldn't prove it. But it ended up being such an easy thing that my attorney said, look, we can show it, and they're not going to be able to argue it because it's so blatantly
it's that
true,
blatantly obvious.
This should be easy. Otherwise, bad reviews, is it worth like going all the expense to chase down the
Generally not, because usually, you get to that third element of damages and I'm like, well, have you lost any families yet? And they're like, no. Well, is anybody not like, can you show numbers that like last month you had 50 people sign up, but this month you had 10 people sign up and it was because of that review? No. Well, like it sucks, but you're just going to blow a bunch of money trying to force them to take it down because the legal elements aren't quite there to give you a reason to actually sue them, let alone whether or not it's really worth it for you to sue them over this comment that they made.
Because I've actually had this conversation with gym owners before, kids activity center owners, because there's so much passion involved with their business. They love, it's so important to them that when somebody writes a really nasty review, their heckles get up and they talk like this. They talk about, I'm going to get my attorney involved and blah, blah, blah. My advice on my stories is write a very nice, compassionate response that's written for the people that are going to read the review, not for the person who wrote the review. And then make sure that you have 10 good reviews for every bad one. So when they look at that review, they think that person must be crazy.
Yep.
I wanted to bring that up just because I have heard multiple gym owners and it's more of an emotional thing, right? They're so angry with, how dare that parent say that? They were with us for so long. I put so much effort into the game. Blah, 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 blah. I guess that's where a lot of lawsuits end up coming, is people just angry and fired up. All right. So lawsuits that no one saw coming. Do you have any real stories of lawsuits? You don't obviously need to bring the details, but a lawsuit that just totally unexpected. They had no idea that it was coming. It hit them. And what kind of lessons that you as an attorney came away with it, but also, maybe what your client came away from?
I mean, luckily, knock on wood, I don't get a lot of lawsuits that come across my desk. Doesn't mean they don't happen, but probably because we don't litigate. But I will say,
you spend most of your time setting things up so there isn't litigation.
I spend all of my time setting things up so there's
Right.
not litigation. I mean, I shouldn't say that. I do rarely assist. I'll give you an example of maybe one that people didn't expect, but I'll answer the question is, we're helping a gym owner right now go through an arbitration because they used AI to draft a purchase agreement. And the purchase agreement that AI pumped out had a blatant lie in it. And the SBA, when the buyer was going to get financing, saw this purchase agreement, realized there was a blatant lie in it, and said, no, we're not giving you financing. Meanwhile, the buyer had given $50,000 of earnest money up front and wants that $50,000 back. And now they're in arbitration fighting over this $50,000. That's unfortunately growing more and more common, where AI is now starting to come back and bite people in the butt. Because, I can go on ChatGPT and be like, give me an asset purchase agreement, but that doesn't mean it's going to actually apply to what I'm doing. But to answer more of your question, where we see a lot of sort of more unexpected type of things is just like that personal injury that happens before or after class, when nobody's watching and the kids are all just around having a good time, trying out the new TikTok whatever that they see on there. And, the girl gets tossed up in the air and they miss her and she comes down and breaks both wrists on the ground. And it seems innocent because they're just hanging out before or after class. But then there's this big question of, were they supposed to be supervised? Should they have been doing this? Was this preventable? So it's that kind of that almost element of lack of supervision that the couple of times that we've been called saying, we now have an injury, what do we do about it? It's typically that kind of a thing.
Right.
It doesn't happen necessarily under instruction. It happens when nobody is under instruction and nobody's really watching or paying attention.
Okay. Yeah, that makes sense. And I mean, injuries are always going to be surprising, right? I mean, it's not surprising, but it is surprising all at the same time. When I first met my wife 26 years ago or whatever, the first year I met her, the first 6 months that I knew her, I met her and she's just recovering from a broken foot. She's a gymnastics coach all her life. Broke her foot, but within 3 months, she broke her Achilles, all of which were surprising, but not all at the same time, right? Like she actually broke it jumping into I think it was a forward somersault or whatever, but she was like tumbling in the air and she felt it snap as she launched. And as she was in the air, she was like, God, I'm going to try to land on one foot. And that was surprising. Thankfully, it didn't turn into a lawsuit. We got it fixed and, she's doing okay. She's walking around. She's doing good. So liabilities, we've walked through that. We've gone past that. Although we did talk a little bit about liability from a sales standpoint. Selling your gym someday. What kind of things do you want to think about? Even if you're not necessarily actively looking to sell your gym someday, but you know that someday you might sell your gym. What kind of things should you be thinking about now?
Whenever we're talking to sales, we start with basically saying one of two things. Act today as if you're going to sell the gym tomorrow, or act today as if you're going to be reviewed tomorrow. And those two sentences, from the selling standpoint, basically means act today as if you're going to sell tomorrow, because you're going to want to try to maximize the amount of profit you can get out of your gym. And the primary way to do that is to have systems in place, have staff that know how to follow that system, have yourself removed as much from the gym as you possibly can, have your liability waivers in check, have your insurance policies up to date so we know that we don't need a tail policy. That's kind of another weeds thing. Have your tuition agreements and payment policies put in place so those are assignable to a buyer of your gym. Because if we do all of that, then one, the gym is going to run most efficiently. It's going to maximize the amount of profitability. and it makes it the most sellable. It just happens to. It just sort of fits everything in line so that
Right.
even over the next 5 years, your business is running as best as it possibly can be. And then 5 years from now, it looks fantastic because now somebody's going to come in and we're going to operate the gym as if somebody's going to review us tomorrow through this stage of what's called due diligence. And now we're going to have all our financials put in place. We're going to have all our documents ready to go. And we can turn it all over and make the process super easy without scaring a buyer away.
And it's like the accountant thing. Yeah, it's amazing to me how many times we talk to gym owners, kids activity center owners, and they don't know how many kids they have. They don't know exactly how much money they're making. They don't know exactly all the things that you would think you would need to know. If
Right.
you don't know that stuff, when you're looking to sell it, you've got to like suddenly put it all together, and you might have to put it together for the past 3 years.
But usually for the last 3 years, yep.
Right. And if you can't put it together, it just makes things a little bit more hairy and a little bit less attractive. And really what you want when you're selling a gym is you want it to be as attractive as possible, right? You want
Right.
you want someone to look at this and go, "Whoa, this is awesome. Love
Yeah,
this.
completely.
Let's
Yep.
let's move through." Okay, that makes sense. So basically, get all your documentation together, make sure your contracts are all good, make sure that everything is put together right. Obviously get your business valuation, which probably isn't necessarily what you do, right? Because you
We
do could you
do. We provide market value opinions. So in the child
okay.
activity centers, typically we refer people over to third level consulting. So we hired them about 18 months ago to teach us how to value gyms the same way we do. And then we have sort of a verbal non-compete that they get to do all the market value opinions or get the first stab at them for child activity centers. We get the first stab at doing all the market value opinions for adult gyms. So anybody probably listening to this podcast who's going to come to me and say, "Can I get a valuation for my gym?" I'm going to go, "Great. Reach out to third level consulting first. If for whatever reason they don't want it, come back to us and we'll give you a market value
Right.
opinion." It's not an appraisal. It's an appraisal process, but it's not an appraisal because we're not certified
Right.
appraisers.
But what makes it easier for you is having all this documentation nice and easy to go through, right?
Oh, of course. Yeah.
That's what it is. All right. So when should you actually call an attorney? When should you actually call your lawyer?
Before there's a problem
There
tomorrow,
you go.
today.
And timing, right? So it's like timing. Timing means now.
Yeah.
Timing means do it and just make sure all your ducks in a row. And like Matt said, review stuff, see what changes. Your state might have changed a law. Your county might have changed a law. Your city might have changed an ordinance. Who knows? We need to look through it. Now, not all attorneys are going to know all of these things. Not all attorneys are created equal themselves. But at least, you've got some kind of like level of advice other than yourself thinking that everything's fine because I've been doing it this way for 25 years, right?
Yep. Exactly. It's not exactly set it and forget it, but it's like set it and only think about it once or twice a year. So it's
And that couple of $1,000 that it might take to just review everything, it's probably
Mhm.
amongst the most comfortable couple of $1,000 that you might spend.
Yeah.
So, and then one of the things I've done, like I've used ChatGPT for legal stuff, but what I typically do is I use ChatGPT to organize what I want, and then my attorney reviews and goes, and then they put it together as a legal document.
Yeah.
Because sometimes ChatGPT is useful. I think ChatGPT is useful to help me understand what I want and how I want to put it together and put it together in a way that makes sense for my attorney to look through to actually make it actually a document that makes sense. Yeah, I think it's a big mistake if people like if you go on ChatGPT, I think you are at risk if you ask it, "Can you write me a contract?" where it will say yes,
Yeah.
right?
Yeah. It's not going to say
Danger
no.
is whether or not it will actually fly.
Yeah. Right.
Is the
Right.
problem.
Yeah. I
So
don't have any issues at all
yeah.
with AI. You just, let your professionals do what your professionals do and then fill in the gaps with.
I would never use my ChatGPT to look through my finances and come up with an actual right to the penny understanding. I can't tell you how many times I've seen mistakes that AI does. It's inherently going to make errors that you need to check on. I mean, I've had ChatGPT just write copy for ads, right?
Yeah.
And there's a spelling error in it.
Yeah.
Which you would think wouldn't happen,
Right.
but it has, right? I used and it wasn't like the word was spelt wrong, it was the wrong word that it used,
Okay.
right? So yeah, anybody out there that's thinking of using AI, which we sell it, we've got Kai, we do all sorts of stuff with AI. AI is best used in relation with humans. Right now,
Mhm.
AI is not better than humans. we're probably a good few years before that even happens. And I don't know if humans are anywhere close to actually feeling like they can trust it to the point where they don't have to have any human oversight with AI. I don't think
I think it's a
anything's
generational thing.
right. Right.
So,
I'm a bit worried about when that becomes a non-generational thing because
that's true.
I think there will be mistakes. I think there will be issues. So if I bought a gym tomorrow, what is the list of things? So I'm guessing you're looking at go through the contracts, look at the waivers, look at your HR stuff like your employee handbooks, look at your policies, look at the documentation, look at your insurance. Would that be kind of like the list of things that, you buy a gym tomorrow, you want to go through all that stuff to make sure everything's lined up?
Yeah, look at your liability waivers, look at your tuition payments and your payment policies, and then look at your staff issues or your staff policies. Those are going to be like the 3 big buckets. There may be more things in there, but those are going to be your 3 big buckets. And make
All
sure
right.
we review your legal entity because you may or
That
may
was
not
my
have
question.
completed that setup.
That was my opposite to selling a gym if you're going to buy a gym. But basically, everything that we've spoken about, just have somebody go through it. Who knows? Don't lay it on yourself. Like, probably an amazing time to go through all that stuff and make sure everything is done is when you buy a gym, right?
Well, hopefully
Like,
we've gone through all that stuff before you bought the gym during
right.
due diligence, so it easily translates after you buy a gym. But yes, if you're going to buy a gym, don't take what the previous owner used and just assume it's correct and try to use it yourself, because that's another one of those.
Well, I think I've
they
spoken
never-
to you about the fact that we actually partner up and we actually do own ownership in multiple gyms of a sort. And actually, every gym that we work with usually has some issue. Like we're trying to rescue them, we're trying to pull them out of a difficulty or take them to a place that they haven't been. They've struggled to get there. And it is a bit of a process to start going through, okay, what's going on here? But I must admit myself, have I asked for the waivers to be sent through to me and have it looked over? I haven't even done that. So maybe I need to be talking to you about, hey, I need to get these waivers sent over and so forth. So that is really good advice. So last question is basically fast 5, right? Fast 5 questions every gym owner should know. So what is a biggest legal myth that you hear? What would you say if there's one biggest legal myth?
Probably that waivers don't work.
What is the biggest liability that a gym has, or a kids activity center has?
Not having liability waivers that apply to what they're actually doing in accordance with their
Might
state
be a
laws.
lot of the listeners. Biggest HR mistake.
Misclassification of staff.
Okay.
Using
And that
bartering.
Right.
Yeah.
Right.
Bartering in the child activity
trade.
centers is the biggest mistake.
Okay. And that makes sense. I mean, you can pay somebody and they can pay you, right? I mean,
Yep.
you're paying them, like you exchanging dollars.
Just
and
exchange the dollars for dollars, you're fine.
Right. So you would recommend to not do trade for hours.
Correct. Yep. Yeah. I'm happy
So
to do
I
another podcast on those issues.
Right. Exactly. Biggest contract mistake.
Using AI or somebody else's contract that isn't actually a contract. It looks like a contract because you don't actually know what legally needs to be in there, but then we're actually missing contract terms.
Yeah. And obviously AI, but absolutely don't just use someone else's contract,
Yep.
right? Because you don't know, 1, if it's good. You don't know, 2, I mean, you can use it, but send it to Matt and get him to look over it and make sure that he approves it, right?
Yeah.
Tell me, what should every owner do this week? One thing that you would recommend every owner do this week.
Search through your things to see where your corporate documentation. So do you have a set of shareholder agreements, bylaws, operating agreements, whatever applies to your corporate entity? What's your insurance policy? And when was the last time you reviewed it? What's your liability or your commercial lease? And when is it up for renewal? And what do you have to do in order to renew your lease? When was the last time you reviewed your liability waiver? And do you know whether it applies to what you're actually doing? Is your tuition agreement up to speed with your consumer protection laws? And do you have your staff classified correctly and under the appropriate staff agreement? And if you can go down that checklist and you can check everything off and you reviewed everything in the last 6 months, you have nothing to do this week.
Okay.
And if you go down through that checklist and you're like, I don't know anything about this corporate documentation. I don't know when the last time was I looked at my insurance policy. I don't even know where my commercial lease is. We haven't looked at our liability waiver in 5 years. We should be doing something about that. So
you just get your ducks in a row.
Yep.
And that's
Just
a
review
checklist. That's just kind of like a health checklist, right?
Mhm.
Business, legal health checklist.
the legal checkup. Yep.
All right, man. Hey, it was really great chatting with you. Thank you
Thank you.
for joining us. We'll chat again. I just want to remind everybody that's got to this point, thank you for listening for 55 minutes and getting
About
to
the
this
law.
point of the video, about the law. Sure, it's really exciting, but I think it's really interesting, right? But just for everybody to know, Matt's going to actually be at National Congress speaking this year in Phoenix. So if you get a chance, definitely go to his presentation. And if you get a chance, say hi to him and shake his hand.
Come on up.
And connect. So with that, Matt, thank you for joining.
Thanks,
and
Andy.
do you want to share any information if somebody wants to reach out to you right now?
Yeah, honestly, the easiest way to do it is just to go to the website. There's calls to action all over the website. And if you just put in your info, you will automatically be forwarded to my scheduling calendar. You can grab 30 minutes with me.
And what is your website?
Gymlawyers.com. Great question.
Awesome. Well, thank you, Matt. We'll talk to you soon.
Thanks, Andy.
Thanks, buddy.